So this is Legal Committee December 2024. We'll do roll call. I'm not seeing Linda Fenhoff. Okay. I see Crystal is on.
Yes.
In the room we have Ronnie, Jenny, myself, and I do not believe that Dominic is joining us this evening. So we have a relatively short agenda this evening. Go to the documents. The first item that I wanted to discuss is the local law interference, harassment of city officer, code enforcement officer, or building. Can you pull that up, Logan?
Yeah. The daycare,
No, the harassment law.
Yeah.
So I think, Chris, if you give us some background on this, I have a couple of questions about this. So I believe this originated either from the president of the council or from the mayor's office. I'm not really sure. It did not originate with us. And my first question around it is, are there not New York state laws relating to harassment that will cover this issue?
The issue has been that the laws in New York State are more of a violation as opposed to a misdemeanor. So what this does is it takes it, well, first of all, it expands it a little bit more and specifically defines, who in the city, which employees of the city specifically should this pertain to, and the types of harassment, the fact that it's harassment involving their official job duties, not a personal situation. And then the second part of this is that it makes clear that this is a misdemeanor violation, which affords certain additional protections to individuals that are subjected to harassment as opposed to a simple violation.
So can we talk through exactly who this covers, first of all?
Well, I know that at the council meeting, there was a request to actually expand this to make sure to have it cover not just the officers, but also the staff of the departments. I haven't made that change yet because I wanted to see if there were other changes that the legal committee were going to want to make. But that was one of my intent. One of the things that I took out of the council meeting from last month was to expand this, make it broader, so it essentially applies to the staff of those departments.
So it applies to building inspector. Do you want to scroll down now so the public can see it? Building inspector, city officer, any individual listed as an officer, code enforcement officer, and the harassment is defined as what? Just walk us through how harassment is defined.
Well, the harassment is essentially repeatedly, not just annoying a city officer, but it has to be acts of either, it has to be serious enough, one act that's serious enough, or repeated acts that interfere with that officer's job responsibilities. And that's part of this here, is it has to actually be harassment that is directed to the person in their official capacity, as opposed to a personal capacity.
So the first item, strikes, kicks, or shoves, that does not have any repetition on it. The second item, engaged in the course of conduct repeatedly, commits acts which alarm or seriously annoy. So that's where
yes.
the repeated piece comes up. So again, and I want to hear what others have to say here. What problem are we trying to solve? Is there an ongoing problem of residents in the city on a regular basis harassing city officials? By that I mean more than one or two. Is this like something where we've got 15 or 20 people who are a problem and that the officers and city employees are constantly subjected to harassment from the populace as a whole? Or are we talking about one or two people? What problem are we trying to solve?
It's not one or two people.
Well, I'm not going to ask Crystal what problem this is solving.
No, the law, nor should it be directed at any individual person. It should be directed to correct, to remedy a situation or to address a gap in the law that doesn't address a situation as a whole for the city. So this is not it, nor should it be perceived as being focused on one individual or one or two individuals that could be causing problems.
So, right, but what problem has been identified is the question I'm asking.
I would have to go back and talk to, I remember that the request came in. It was either from a city council, it wasn't actually from the council president. It was actually from one of the city department heads, is my recollection, but I'd have to go back and take a look.
Okay, and so Jenny, you're saying it is multiple people that are? So what's your knowledge of that?
My knowledge is that if you walk in back in the city clerk's area, they actually have a list of people that come in continuously and scream and threaten them. There's girls upstairs who have.
If I may say, if this discussion, Jenny, if I can just pause for can I pause for a second?
Sorry, Crystal, hang on a second. Sorry?
No, this is, I want to interrupt for a second, because if there is a broader concern that is regarding a specific situation, that could be appropriate for executive session. So that's why I just want to say that's not necessarily a conversation to have in open meeting.
Okay, thank you. The reason I'm raising these questions is that if we're talking, the first thing, obviously city employees should not be harassed. And I was just trying to understand why we need to go beyond New York state law. Why do we need a separate law with a resolution stating that we will ensure that New York state law is complied with, be sufficient? And if indeed it's an issue of one or two individuals where there's a focused problem, then there are other mechanisms for addressing that other than a broader law, such as protective orders. So that all I was trying to get at was what problem are we trying to solve here? And so if there is, as you say, Jenny, there's a list of what, a dozen people that are a problem? Okay. What are your thoughts on it?
My only kind of just clarifying question is, Crystal, is there like a legal understanding of the word as it pertains to this law, to annoy? Is there an accepted understanding of that word? Or because someone, city employee might feel annoyed at just at the sight of someone, but they might have a legitimate business. But if there is
part of this is not just a city employee who's going to be, who creates, who essentially results in a conviction. They don't say it and it becomes, they don't say a resident has annoyed me and thus that resident is now convicted of a misdemeanor under this law. There is going to be discussion with the police. There's going to be a level of discretion at that level. And then they would have to go through an actual, proceeding, a court proceeding, where it is found that that actually happens. So it's going to be, and that's why you're looking at it with the, repeated conduct, and it has to be interfering with that person's, with that city official's performance of their job duties. That's going to get to that level.
I have another question. When you say the law as it's written, the state law, it's a violation, what happens to a person if they receive a violation for harassment?
I'm going to have to say that I'll have to do a little bit more homework on that. I can tell you right now that if it's not a criminal, if it's not a misdemeanor, then there is, for example, like orders of protection. you're not going to be able to get an order of protection or a stay away order if it is not an actual crime, if it's not a misdemeanor. And that is one significant difference between a violation and a misdemeanor situation.
So, Crystal, under the first item, strike, shoves, kicks, or otherwise subjects a city officer to physical contact or attempts or threatens to do the same. Isn't that assault and battery? Wouldn't that be covered under state law?
It is, I would say it is assault, but there is, there are multiple situations where you can have multiple laws that cover similar conduct. So that's where you would see someone get charged with multiple violations or, of different statutes.
Okay. Right.
Are we gonna think of?
Okay, so, hang on. I'm gonna ask the public for comment in a second. Jenny, do you have anything else you want to add on this?
No.
Ronnie? So you're both okay with sending this to the full council for review and discussion?
Yeah, I think, to Crystal's point, I think we could add city employees
I
because
think we should.
if it specifically hinders their performance of their duties.
Okay. Good for my hearing aids.
Crystal mentioned that city employees was suggested as an addition.
Yep.
Or expansion to this law.
At the moment, it refers to officers.
Yeah.
Let me just turn on this. Okay, so,
We're gonna allow to cover the clerk, but not her.
so do we have any
Let's
comments in
have
the
end
room?
of parking enforcement, guys.
Anyone identify yourself and your reference?
Sure, my name is Claire Cousins, I'm supervisor in First Ward. I live on Union Street. I was gonna expound on what Crystal stated about the orders of protection. It's really hard for an elected official and a city employee to get an order of protection because the nature of your job is to engage the public, and if you're not going through a full court proceeding or there's not something criminal happening, you're not gonna get an order of protection. So I think that this is something that does protect employees and elected officials from the harassment that they're subjected to sometimes from folks that don't understand the capacities of their jobs.
Any other comments from the public in the room? Okay, we have one hand raised. Ron, oh no, two hands raised. Ron, do you want to comment?
Yes, I have some observations and questions about the law. I just first would like to note that basically the Hudson Law, beginning with Section B, repeats the wording of the Albany Law almost word for word, with the exception of expanding its scope to include all city officers, which the Albany Law does not include. Code enforcement officers, DGS workers.
Ron, we've lost your audio.
Okay. My mic is supposed to be operating. Can you hear me now?
That's a little better.
You can hear me?
Yep.
Yeah, a little better.
Okay. I was just going to say that the Albany law is narrower in scope and does not apply to all city officers, and it seems to have referred to people who are actually out in the field and not to anything that might occur, for example, at a meeting of the Albany City Council. I would like to ask, I mean, maybe this was touched on, but have there been any incidents in Hudson recently where any city officer has been, anyone has struck, shoved, kicked, or otherwise subjected a city officer to physical contact or attempted or threatened to do the same? Have there been incidents of that?
Ron,
So,
I know of.
Crystal, hang on, Crystal, without going into executive session, is that something that can be responded to at a general level?
I would, on a general level, yes, but if there are incidents of it, I would not, that should not be a discussion in open meeting. As there could be investigations that are undergoing, I would need more information before I would feel comfortable with that being a conversation that occurs in open meeting, especially a disclosure if it's on someone else's behalf.
Okay, and if I can refer to a specific person, because his actions seem to have occasioned the bringing up of this law, has anyone, to anyone's knowledge, sought any kind of legal protection against Mr. Houston?
I
I'm
would
sorry,
advise-
I'm sorry,
I
Ron,
would
Ron,
advise,
sorry, Ron, we cannot discuss individuals in open meeting.
Okay, all right then. No, no, I have one. Uh, now I sort of lost the point that I wanted to make. No, you distracted me.
Ron,
let
while
me-
you gather,
no.
while you gather your thoughts, Verity Smith has her hand up, so I'll come back to you in a moment.
Okay,
I'm just gonna go over to Verity, she has a comment.
sure.
Verity, you're muted.
Oh, there. Okay, I unmuted. Thank you. Yeah, I just quickly wanted to note that, Margaret, you raised this idea to consider about how is an additional law necessary if there is already harassment law. I'm not saying that you're advocating that position, I'm saying, but to my understanding, you're raising that for consideration. And for me, as a concerned member of the public, I would say that there is a difference and there is a need for an additional law, because when harassment occurs between individuals, there's a harm to that individual. But when harassment occurs to a public official or agency head, et cetera, impeding them potentially from doing their job, it's a harm both to the individual and to the public in a pretty direct way. And so Crystal, you did point out that, of course, there are often overlapping things where someone could be charged with more than one thing. But just to note that I think there's a pretty clear additional value to something that's specific, whether the wording should be tweaked or not, to kind of make it clear that this is meant to protect people for not only as individuals, but so that they can continue to do their jobs, so that we're not all harmed by these kinds of disruptive, harassing actions. So anyway, my
Yeah,
thought.
Verity, you're correct, but I'm just trying to understand, why do we
Yeah.
need something over and above whatever New York State
Of
has? I
course.
just wanted to be clear on that, that's all.
Yeah, no, I assumed. I mean, it's a good thought exercise. And I guess my response would be what I said, that
Yeah.
that's my response to people that would argue potentially that it's already covered. I actually think there is value in fleshing out this dimension of the harm, and specifying people not only as individuals, but as public servants. So thank you.
Okay, thanks. Ron, did you want to comment?
Yes, I just wanted to say in terms of what I asked about a particular individual, I was trying to get at why that person had been banned from attending meetings in person, and if that had anything to do with anyone having sought any kind of legal protection from him. But beyond that, what my real concern here is the effect of this law on speech. Let's say someone comes to a meeting of the council or some other public forum and has not sent all caps threatening emails, has not followed people to their place of work or at home, has not turned up unexpectedly on somebody's front door, but asks questions which are critical and probing and perhaps might be construed by some as annoying. Would that kind of speech be subject to this law?
No.
I don't think so, I don't think so.
And I think our
no,
track
and
record
there
as a
are,
council speaks to it too. Right, accepting.
Ron, this is not really about the council. This has more to do with day-to-day people doing their work, doing parking tickets, doing code enforcement, building inspectors, DPW, trying to patch holes, that kind of thing.
But then it was
It's not-
expanded. The law was expanded to include all city officers, and I have to come back to the fact that the occasion of the law seems to have been an event involving speech at a council meeting. And as a further,
I don't think that's intended. I do not think that that's what's intended. And Crystal, is there a way to make sure that because the intent here is not to impinge on free speech.
So
I had a further question as
speech,
to whether it could be applied, for example, to something like a blog, in which either the person running the blog or people who are allowed to post on the blog might say things of a critical nature, which might be construed as annoying or harassing on the part of certain city officers.
so there
I
are
think,
clear,
Crystal, can we clarify it so that it's clear that this is about harassment that actually prevents people from doing their job? Because I
we
think that
can
would
do,
get to what Ron is bringing up.
we can add that in the intent section of the law. What I would say though is that there are clear speech protections that are outlined in New York state law, New York state case law, and federal case law, that the type of concerns that are being raised, they would not fall under this as harassment. They would, it would be protected. And there's very clear parameters already set out in our laws, both federal and state, which cover those situations.
I think this should be made explicit in any law you draft. And I think that if the city is going to draft a law, I don't think they should lift a text verbatim from the.
Ron, we lost you.
We often take,
Yeah,
Without
just
the-
just to address that, all municipalities, not just Hudson, typically do not they don't want, no one wants to recreate the wheel when it comes to these things. So oftentimes what you will see are municipalities taking other laws and tweaking them for the situations that they want them to address. I did take a look at the Albany law. I did expand the scope of the Albany law when I was putting this together. It's a common practice for all municipalities and all municipal attorneys to do that when they are drafting laws.
Okay, but in this case, I think this is a fairly serious issue. I would say don't, just lift the text. I think this law should be thoroughly discussed and debated, and I think it should be drafted from instead of basically taking over the Albany law. And the protections that you mentioned regarding speech, they should be made explicit in whatever law you draft. Thank you very much. I'm sorry, Matt McGee would also, Matt McGee would like to speak, but if there's somebody else to go before him, by all means.
Well, I just want to come back because Ronnie had raised this question as well. Acts which alarm or seriously annoy a city official. I would really like to get a tighter definition of annoying a city official. That's kind of,
Yeah.
I mean, is there other language we could use here? The language of conduct that impedes a city official from doing their work or something like that. But I mean, getting annoyed should not be sufficient means for sufficient cause for somebody getting a misdemeanor.
well, I was, when Crystal said that this is not something that automatically causes
Right.
conviction. So it's something that has to be proven in a court of law. I think a court of law would be able to.
Right, but just, I
Yeah.
mean, I'm an annoying person. So do I have to go to court and defend myself for being an annoying person just because I'm an annoying people? I mean, I'm serious.
Maybe you would get licensed to
Margaret, we can tighten up the language on this. I can add language to tighten it up so it's more geared towards impeding official duties.
Okay, that's fine. So going back to the public, Ron, I think you said Matt wanted to comment?
Yes, he does. Here he is.
Yes, I'm rather quite bothered by this potential of this.
Can I hear you?
Matt, we can barely hear you.
Yeah, we need
I'm
the
quite
mic turned up.
bothered by the potential of this law to dampen speech because it's not, when you apply it to the city council, this is a chamber where people are supposed to be able to feel that they're able to speak freely and express their opinions. And I think that this would inhibit the freedom of speech that we are guaranteed by the Constitution. I think that including that in it is excessive and goes well beyond normal practice of government. And I think our rights should be very clear and very well understood, and there shouldn't be impediments raised to having the ability to speak out and express grievances to your government. Thank you.
Thank you. So Crystal, if you could take that back and maybe be explicit about protections of speech. That this
I
was
will
not
work on the
speak-
language for that. I want to be careful with how we. I will work on revising the language.
Okay, okay. If we have no other discussion on this, we can move on to our next agenda item. Next agenda item relates to daycare. This is something that came up that I requested President of the Council to have it come through legal, and I discussed it with Crystal. Little background here. Currently, the code, Hudson City Code, daycare is not a permitted use anywhere in the city of Hudson. So this is something that we need to address. For example, the development proposed on State Street by Carney, one of the features of that development was a daycare on site, which our current code would not permit. And so it wouldn't just apply to this, but there are other scenarios where, and I discussed it with Craig Haig, getting waivers, getting some ability, doing it on a case-by-case basis is very, very difficult. So we need to adjust our code to address where we want to allow daycares. And under New York state law, there are two different definitions of daycares. There are licensed daycares, and then there are legally exempt daycares. The version of this code that I first saw, and when I discussed it with Tom and asked how it come through legal, did not address the legally exempt daycares. I just want to speak about those for a moment. Those are typically in-home, informal daycare for up to 3 children. They do not require a license. They're a very important part of the daycare landscape. And they're many parents don't want to put very young children into a formal daycare. Very often less expensive than a formal daycare. It also is a good revenue source for an individual who is staying at home, etc. So I wanted to make sure that when we did this, if we're going to fix the code, that we address both that informal daycare, which ideally should be basically any home in Hudson can have informal, legally exempt daycare, but then also looking at the way the code was revised was put in R1, which is residents, single family residents, and then that has a ripple effect of the entire city. I have hesitations about that. I discussed that with Craig. My primary concern there actually relates to the properties in the 5th ward. So if you think in terms of property that you might purchase, because legal licensed daycares in New York have certain requirements for outdoor space. The locations of properties in the city where you might have a single family home, the section of the 5th ward I'm thinking of is zoned R2. Those are single family homes. It's a building that could be converted into a daycare potentially, has sufficient outdoor space and so forth. And I'm not sure that we want to say that you can have a commercial daycare in the middle of residential area. So what I would recommend is that we look at R3 and beyond, which was something that Craig Haig actually suggested that we consider. That would essentially cover most of the city. It would ensure that apartment developments and so forth would be able to have on-site daycares. And then you wouldn't have potential issues with the 5th ward area. So Crystal was going to work on new language, new code, updates to this, but I want to throw that out there for discussion. But we absolutely have to address the legally exempt informal daycare. Essentially that occurs in somebody's home. So any home in Hudson could, like my next door neighbor, could have an informal daycare. Right now, if my neighbor was taking in children, I could go to code enforcement and the code would support me in saying that that person can't have an informal daycare. I think we need to take care of that. It's very easy to do. We just say that's applicable throughout the city. One of the things that in my discussion with Craig that he brought up also was that you wouldn't want to have daycare, for example, in the industrial zone. Well, I don't think that's really going to happen. And planning board could address that if it came up and say this is not an appropriate location. So I think we went with R3 for the licensed daycare and then R1 for the legally exempt daycare. So I want to throw that out there for comments. Jenny, thoughts?
Why wouldn't we do R2? Just because they don't have sufficient space outside?
No, because if we do it at R2, so if you think about what Hudson looks like, right? So I'm going to take Union Street as an example, like you think of the Victorian houses, very little outdoor space. Those spaces and also those properties in terms of the valuations, those would really not be suitable for a commercial daycare to purchase and convert into a daycare, right?
Okay.
So that's not going to happen. In the boulevards and in the Fifth Ward, however, where you have bigger plots and you have a one-story building, it has more potential for an investor to say, I'm going to purchase this home and turn it into a commercial daycare. And I think that could potentially be an issue for people living on either side of that daycare who do not necessarily want to live beside a daycare with 30 kids all day. So the concern that I have is to protect that part of those residences from expansion. We want to make sure that something like the Kearney development or an apartment building can have a daycare. So by going with R3, that would cover that, right? But it's highly unlikely that half of Union Street is actually zoned commercial. But it's highly unlikely that just because of the structure of those buildings and the fact that there is insufficient outdoor space to get a license to do a daycare in that kind of setting, it doesn't comply with the requirements. So that was why I was thinking let's carve it out so that we protect the single family homes in the Fifth Ward. Ronnie?
Yeah, I think the portion of your concern regarding the exempt could probably be taken care of in the intent section just by excluding that, right?
Say that again?
Section 2 where it says intent and purpose, we could just include.
Well, the
Sentence
current
there
version
is-
of this doesn't really, where is section 2?
I mean,
The current
section 2
version
specific,
only addresses the license
right,
daycares.
wouldn't that automatically preclude the exempt daycares?
This, as currently framed,
Hmm.
this would not permit my next door neighbor to take care of 2 kids. Because the only thing it allows for is licensed daycares of 3 or more children. It does not allow for the informal situation, which I had a concern with. And we do know that people take care of kids in their
Yeah.
homes. We just want to make sure if we're updating the code that we take care of that as well. So that's not something that's.
I also understand your second concern about not wanting to live next to it, but I don't know if that's really a good rule to judge a situation by when we're in such.
I'm sorry,
small-
speak up.
When we're living in such a small city, it's
You're
tough
not
to
sure
like,
that's a
yeah,
legitimate concern?
I'm not sure if it is
Okay,
a huge enough concern
Yeah.
for it to be,
so you would lean towards R1 for everything?
yeah, I honestly don't see a huge issue with it. Cause I mean, what is the potential for,
Very limited, I think.
yeah,
Mhm.
yeah.
I think it's very limited.
And if even if it was, approved addition per zoning, do they not still have
It still
to?
has to go to planning board.
Exactly, so
Yep.
that would be
Yep.
the checkpoint for that, I believe. That could,
So you would favor doing R1 across the
I
board?
think it's just leave it open-ended and let.
Okay.
Because that allows more potential for, because daycare is something we need.
We absolutely.
I do agree with the first part where if we can make it so that it's easier for informal daycares to
Yeah.
exist.
Yeah.
Why not do that?
Yep. And I do know of a case where there was a complaint.
Yeah.
It wasn't held up because the individual was taking care of relatives, actually,
Yeah.
children. So that doesn't apply. But I think we need to make sure that that type of daycare is protected. So Crystal, it sounds as if, Jenny, you also think leave it at R1 across the board?
I mean, I think Rudy's right, you know, if somebody's gonna open a big daycare,
Even 15, 20 kids, it's a lot of
It-
kids for a small house.
yeah,
Probably
it's
not doing it.
really gonna be a rare situation that even anyone would even go to the planning board and say, hey, I'm gonna take a section of my home and.
Well, you wouldn't do it as a section of your home. If you were an investor and doing commercial daycare, you would purchase a property in the boulevards and you would convert it into a commercial property to meet New York State licensing requirements, because the requirements are very specific.
But I don't think that you could.
It wouldn't
have-
be your home. It
It's
wouldn't
a
be.
zoning thing then.
Yeah, at that point, I think the planning board could take it
Yeah.
as
Yeah.
an individual basis. I just don't
Right.
think we should just.
The
Not
licensed
allowed.
daycares are typically not like, I'm converting part of my home. It's usually more of a scenario where you're,
I was just thinking of my own home and thinking that the whole downstairs could be converted if
Right.
I were allowed by the zoning board to convert it and I could live upstairs.
Right.
I don't know, there's a lot of two-family homes around,
Right.
so, yeah,
okay.
yeah.
So, Crystal, it sounds as if the group, is recommending that you keep it at R1 across the board, and that what you and I discussed, adding in language to ensure that the legally exempt, which is the informal daycares, are added into this so that they are also permitted under the code.
Okay,
Okay,
Clear.
so comments from the
I have a
room?
question, for the informal daycares, I know that they have to go through a process with the state, it's a whole application process. But if the daycare's in their home, they don't have to come in front of the zoning, so.
No.
So how do they're protected under the zoning law, but how does that, just if there's a complaint, then they would be protected?
Right,
or-
so, yeah, so right now the situation is, if my next door neighbor was taking care of 2 or 3 kids,
Right, I heard.
and
that.
I complained,
Right,
it would probably stand up. My complaint would probably stand up. We want to make sure that that doesn't happen. So that if somebody is taking care of a couple of kids and I want to complain about it, code enforcement says, nope, that's a permitted use. You don't have any complaint. That's what we're trying to make sure.
and then the other comment that I had was just about, in regards to like the fifth ward, I think like a daycare center belongs in the fifth ward. Like that's the most
That's fair.
family friendly, easy access for working class folks to, want their daycare to be, so we should welcome it.
So let me just see if there are comments on from the public, and I don't see any hands raised. Okay, all right, Crystal, do you have any questions from us, for revisions you need to make? I think it's pretty straightforward.
no, I think it's straightforward. I don't have any questions.
Okay, so we should be able to get that revised then to, the informal, hopefully next week, so that it can be.
Yes,
voted on.
both.
Okay,
Both the daycare and the harassment law will be revised for the informals, for the informal for next week.
great.
Crystal, if possible, would you mind sending it out before the informal, just in case we need to,
Yeah,
not necessarily ask you for adjustments prior to the informal, but we could bring it up. At least we'd have
Yeah.
prior to. Yeah, thank you.
That won't be a problem. I can do that. Yep.
So the other 2 items on the agenda, we don't have documents for this. I just want to put them on there so that we're aware of them, that they're going to be coming up. One is the accessible dwelling units. This is something that Crystal is working on. I think it may have come out of your office, Michelle. But essentially, we're working on making revisions to permit these dwelling units. So if you think about the structure of Hudson right now, a lot of the older homes like carriage houses and so forth already have these dwelling units. And what this will do is make it possible for other properties to do these accessory dwelling units. This is something that a lot of different municipalities are doing to try to address issues of housing shortage and so forth. So these are accessory dwelling units. I just wanted to put it on the agenda so that we know, hopefully next month we have something to look at relating to that, but that's the intent of that particular piece.
I had a couple of questions, I guess. Has anyone talked to the fire department about this?
Crystal, do you want to respond? I have not been involved with this yet because I haven't seen any language on it. Crystal, do you want to respond on that?
I haven't spoken with the fire department. My conversations have been with Craig Haig and the city zoning attorney so far. But if anyone's going to be essentially retrofitting or building a new accessory dwelling unit, it would have to be done to code, both fire and
Okay.
building codes. So all of that would be required. Where you might see, some issues is if you've got grandfathered ones that are already, in the city that already exist. That's where they wouldn't necessarily be required to be brought to code unless there's a substantial modification to the structure. But that's going to be the case as they exist right now anyway. So it's not, that really won't change much.
Ronnie, any questions on it?
No.
Any questions from the public on this? So we should have something to look at next month on that. The other item, which I'm keeping on the agenda so that we know that it's there, short-term rentals. Michelle, I know that you are working on identifying the rentals and so forth, and probably need to connect with you to see exactly where things stand, particularly with regard to penalties and so forth. But I just have it on here as a placeholder, as something that we need to pursue further.
Okay.
Okay.
I'll just have a question.
Yep.
The last council meeting, there was a contract put
Right.
forward for the software, and I think you want to table it. Did you have any questions about that?
Yeah, so I do have questions, and I'd like to discuss it with you because I want to see exactly. I had questions about the fact that the work product belongs with the company if we do not renew. I have some very specific questions about that software, and so probably be most efficient if I talk to you and got more detail on it.
Yeah.
But the work product situation, to me, depending on how it's structured, if they're developing a database for us of where they identify and so forth, if that is something that we can access, but it's not local to our own environment, and we don't renew, then we lose that, as opposed to actually having that database be ours because it specifically says the work product is theirs. That's one question I had.
Mm-hmm.
The other is, given that the number of units that you have identified, I think it's like 60 to 70 in the most recent numbers that you had for us, they're going to charge us 3,500. I think it was, I can't remember the exact number, but 100 would be 3,500, right? So they're going to charge us that regardless of whether or not they identify 100 additional units that we didn't know about. So just had some very specific pricing type questions about it.
Yeah.
So we can just talk about it. I think that might be more efficient.
Sure. Yeah, I'll just be, this is gonna be like, this contract will be about half of what we're currently paying.
Right.
So.
Right,
it is
yeah.
gonna be-
No, yeah, so the questions I have were just very specific.
Okay, sure, we can connect it.
Yeah, okay, that sounds good. Does anyone else have any new business? Anything from the public? Oh, Karen.
I just had a question. So it's about other entities that are under the city's purview. I asked a question of a lawyer of HCDPA, haven't gotten a response yet, but I'm really wondering about the answer to my question. What is the next step to get that question answered? A legal question that I had about point of order around meetings. Who should I go to?
Is it an HCDPA question?
It is an HTTPA question. I asked it to the lawyer. I haven't gotten a response, so now I'm calling to legal committee meeting to see is there a process that exists here that I can reach out to?
Which lawyer did you speak to?
Christine Shale.
So Chris is the lawyer for HCBPA.
Correct, and I haven't gotten a response, so now
So,
I'm coming to
you
legal
could,
committee to
well,
see if I
I
can
would
get.
recommend that you correspond with Crystal, because Crystal is the lawyer for the common council.
Great, that's the answer.
Yeah, yeah, and if that's not
Corporation
what you
counsel.
need, then you could go to, Andy Howard, who's the city council.
Alrighty,
Okay.
thanks.
Any other questions? Motion to adjourn? Second?
Second.
Okay, thank you, everyone.